and welcome to this discussion on the reform of UK data protection law. My name is Victoria Horden, and I'm here with my colleague Sally Anaro. And when Sally and I sat down and thought that we would put this webinar together a few weeks back, we didn't know for sure whether or not we would get this new data protection reform bill. But as you will probably know, we now have a draft bill published about a week ago called the Data Protection and Digital Information Bill. Now, it's a lengthy document and there's quite a lot of complex drafting. It actually comes in about 190 pages. And in the 30 minutes or so that we have today, we're obviously not going to cover everything in detail. We're really going to concentrate on the data protection aspects of the bill. And we really see this as a bit of a headlines or a taster, because there's going to be a lot more to say about the bill in the weeks and months to come. Please do submit any questions that you have through the Q&A on the website, on the webinar platform. We'll do what we can to answer your questions at the end of our session. So, Sally, how did we get to where we are now? What sort of was the background to the bill?
Well, data protection reform was part of a wider national post-Brexit data strategy. It was published in December 2020. And one of the missions of that strategy was to secure a more deregulated, pro-growth, trusted data regime as well. So, a tall order, really. That led to the government issuing a consultation in September 2021, and that looked at possible ways to reform data protection law. And it was wide-ranging. There was nothing was out of bounds. So there were some quite radical suggestions that were being made. There were suggestions to do away with things like record keeping, the role of the data protection officer, eliminating cookie banners, and getting rid of the obligation to carry out data protection impact assessments. And then there was also suggestions around perhaps how they could refine definitions or make certain terms of the law clearer so that organisations could more effectively understand and deal with their compliance obligations. And then in June, the government published its response to that consultation and its priorities given that for legislative reform. And a few examples of some of the things that it looked at that point. It was talking of amending the accountability framework by replacing it with a privacy management programme. It was talking about creating more exemptions to cookie and marketing consents, taking a more risk-based approach to UK transfer adequacy assessments, among other proposals. And so we were sort of getting our teeth into the consultation response and preparing for this webinar, and lo and behold, within very short order, we have the bill. So focused on that instead. And that came out on the 18th of July, which was last Monday, and as Vicky's already mentioned, substantial document covering a whole range of provisions, not just data protection provisions, but other data-related provisions as well.
Yeah, and it's quite complex to get your teeth into the drafting because it amends all these pre-existing laws. But what's the next stage then in the process? That we've just had this bill laid before Parliament, sort of what happens next in terms of when it might become law?
So obviously we're sort of in slight change flux situation at the moment. We don't quite know who's going to be leading
the next Prime Minister.
I know that there is a second reading for the bill scheduled for the 5th of September.
Right.
And obviously then you've kind of got the committee stage, you've got the court stage, you've got the third reading. So I think it's going to be, and then we also look at obviously the leadership campaign as well. So not quite ambitious to be thinking the end of this year, might be more likely next year. But who knows? There is a lot of drive behind removing unnecessary burdens and so perceived EU red tape. So perhaps this will be something that's
true. A new Prime Minister might really prioritise this. That's true. Are there any big surprises in the response or the bill, would you say?
Well, you could say that the surprise is that there is no surprise because we obviously were aware of the consultation response, and we were conscious that in practice actually sought to try and walk a middle line between creating flexibility whilst maintaining protections for data which are important to an adequacy status that we will maintain with the European Commission. So when the bill itself was published, it did largely seek to reflect the intentions that the government had set out in its but I think a few points that I would flag. There are a couple of areas where the consultation response committed to a certain course of action, but then appears to possibly have stepped back slightly from that. So, for example, there was talk about the privacy management programme, but I've been hunting through it. I can't find any reference to privacy management programme, so it's possible that will follow by web guidance.
Yeah, that's true.
Commissioner. Actually, the response itself also perhaps took a step back from an immediate ban on cookie bans. So, but the bill itself has a reserved position. The Secretary of State can issue regulations down the line which would allow the use of technology to express preferences on cookies. Another interesting development is actually the fact that there are some more onerous obligations in the bill. So it's not just all about sort of loosening up compliance obligations. So, for example, communication service providers have a new obligation to notify the Commissioner about marketing breaches suspected marketing breaches that come to his attention.
Yeah.
And then one other point I'd flag is around just the amount of leverage that there is in the bill for the Secretary of State to issue regulations. And some of that is just because they needed to kick the ball down the road.
Yeah.
They've not tried to address a particular legislative objective in the bill itself. They're going to do it separately by way of regulation. But also it's the ability to create additional exceptions or additional rules, and also the ability of the Secretary of State to perhaps set direction in certain areas, such as perhaps the strategic priorities of the Information Commissioner, or around urgency statements where they might issue their own regulations in relation to certain transfer scenarios, which I think the European Commission will want to look at quite closely to take a view on whether that can be seen in any way to diminish the Information Commissioner's independence.
So there's just a bigger role politically for government in this new regime.
Well, 282 separate references to Secretary of State in the bill. So there's quite a lot of heavy reference to the Secretary of State in there. A big area of focus, obviously, I mentioned, was around reducing barriers to innovation and that sort of pro-growth agenda. And one of those areas they wanted to focus on was processing of personal data for scientific research in that context. So what steps has the government taken there?
Yeah, so in the context of processing personal data for research, this was one of the big selling points of this reform of the law from the government's point of view, to promote innovation and enable the market to be more flexible, effectively, in carrying out research. And I guess there's some tidying up amendments that we might say haven't really shifted things dramatically from what we have under the GDPR. And then there's a few other aspects which I think are a bit more interesting. So the tidying up amendments are things like, for instance, the definition of scientific research, which was sort of interpreted to some extent in the recitals, has now moved into the main body of the law. So we actually now have that set out in the law, but the definition is broadly similar to what we had in the recitals. Secondly, there's this idea of broad consent to certain specific areas of research, which again is something we have in the recitals to the GDPR. That is now in the main body of the law, to just set out more prominently the fact that people can give consent to broad areas of research. So that's designed to try and make it clearer, help organisations to understand the opportunities available to them. But interestingly, one of the things that the government did look at was introducing a new lawful basis for research under Article 6. Now, they've not gone ahead and done that. It was in their consultation, but they indicated in the response there wasn't sufficient support for that, so they've not gone ahead and done that. In terms of some of the other aspects that they have gone ahead and done, one of the different things that they're doing is for providing a privacy notice to individuals in the context of scientific research. If you collected the data originally from the individual, and then you want to use the data for another purpose which is connected with research, you're able to be exempt from that requirement to provide a further privacy notice if you can argue that there's a disproportionate effort, or it would just be impossible, effectively, to provide that privacy notice.
So it's a form of extension of the current disproportionate
Exactly, because the disproportionate effort at the moment only exists under Article 14, which is when you don't collect the data directly from an individual. So they're trying to allow for the fact that in the future, in circumstances of research, if you want to use the data for a secondary research purpose, and you prove that you can do that within the confines of the law, you can go ahead without having to notify individuals if you can argue disproportionate effort. So I think that that may well be quite useful for some in the research community. The other thing to mention is the old sort of Article 89 that we have, which sets out what we mean by sort of the scientific research framework about encouraging things like pseudonymisation and minimisation. If you're processing personal data for scientific research or research more broadly, we're now going to have to sort of, from a UK perspective, see that in a slightly different guise, because that's now going to be replaced with a new article, which also sets out some of the appropriate safeguards that you're specifically expected to put in place in the UK. Now, to some extent, that doesn't differ substantially to what we've already got in the Data Protection Act 2018, because what the new bill is doing is just bringing these provisions together in one place. So the requirements around arguing that it's scientific research processing, and then how you demonstrate the appropriate safeguards. So there's going to be a little bit of getting used to that new framework, but I don't think that's a substantial change. And then the other point just to mention here in this section is around further processing. So again, what the government has done is set out specifically around processing and for a new purpose where it's compatible with the original purpose. And again, very much pointing to this new Article 84, which is the replacement for Article 89, and requiring organisations to make sure there are appropriate safeguards in place. And if that's the case, you can then use data for this secondary use or further processing purpose. So there's quite a bit there on the research side, but some of it actually is not that different to what we've currently got in GDPR.
It's almost trying to help businesses to get more value from the data.
Yes, I think that's definitely a whole theme of what we see in this bill.
Another sensitive area that we're all very aware of is around data transfers. It's currently a regulatory headache for us all. What approaches are government taking on data transfers?
So it's a huge issue, I think, isn't it, for many, many organisations at the moment. And of course, one of the key questions that I expect many of us will have is what impact could this bill have on the UK's adequacy status under European law? So the main sort of issue here around what this new bill brings in is that it replaces Chapter 5 or amends Chapter 5 of the GDPR with Schedule 5 of the bill. And some of these amendments are not substantial, but some of them I think could well be quite significant long term. So just worth bearing in mind what the bill does not go ahead and proceed with, and some of the things that were discussed in the consultation. So for instance, we're not getting a more flexible approach to derogations, and we're not giving exporters the ability to effectively create and design their own adequacy safeguards. I'm afraid that's not happening. But what we have got is a new terminology that we're going to have to get used to, which is the data protection test for adequacy. And in a way, there are two flavours of this test in the bill. The first one is the test that the Secretary of State will apply when he or she decides whether or not a third country or an organisation is adequate. And that says that the data protection test is met if the standard of protection provided to individuals with regard to general processing of personal data in the third country is not materially lower than the standard provided under UK law. And of course, that is a bit of a shift in emphasis, because from a European perspective, we're very used to the idea of a level of adequate protection, which the European Court would talk about essential equivalence. And this new standard is talking about the standard of protection is not materially lower than the UK standard. And it's interesting that means that it could be lower, it just can't be materially lower. And of course, if we're talking about the UK standard, and if the UK law is changing anyway, that in itself is going to be different from the standard under EU law. So I think that is going to be something we're going to have to get our heads around.
I can see guidance coming down the line on what constitutes materially lower.
Yes, exactly. And then the second flavour of the data protection test is where exporters in the UK need to apply that test before they transfer data on the basis of appropriate safeguards. So this is, the language is a bit different here, and it's important to bear that in mind. So this is where the data protection is met if after the transfer, the standard of protection provided for the individual by the safeguards implemented, so usually this would be something like standard contractual clauses, if those standards implemented would not be materially lower than the standard of protection provided for by UK law. So you've still again got this standard of UK law and looking at materially lower, but that's considering once the data has been transferred to the third country, those are the considerations that the exporters need to consider I guess, to my mind, it's not entirely clear what organisations are meant to do if the data protection test isn't met. So obviously we do have guidance from an EU perspective about supplementary measures, about carrying out that kind of risk assessment, and putting in place those additional measures to bring up the protection to the essential equivalent standard. But the bill currently doesn't go into a lot of detail about that, and that again may be something where we're going to get more guidance on. And the issue therefore remains, well, is this likely to concern the EU authorities, this new data protection test? And I expect that there will be some issues raised by European institutions. We may well get some commentary from the EDPB or others, and I know that there's already been some comments from the EDPS, but I expect that they will be looking at this. So, Sally, what about the kind of changes around subject access requests and accountability? What are we seeing there?
Well, clearly, subject access is a cornerstone right of the law. We know, however, that it can place a burden on an organisation when it gets one of these big access requests coming through, and in some cases that right is exploited by individuals. So the bill includes a revised threshold for when an organisation can refuse or charge a reasonable fee for a subject access request where that request is considered to be vexatious or excessive, rather than what we currently have, which is manifestly unfounded and excessive. And the bill sets out considerations where vexatious or excessive where requests might be considered to be vexatious or excessive. So interestingly, that includes a consideration where you take into account the resources that are available to the controller in responding to that request. The bill also gives examples of vexatious requests, and it looks at, for example, requests that have the aim of causing distress or are made in bad faith, or could be considered to be an abusive process.
Yeah.
So I think those are a welcome amendments to
some common sense, perhaps.
Yeah, exactly. In the case of accountability, there's a number of changes here. For example, the requirement for an overseas controller to have to appoint a UK representative, that's gone, that's been removed. The record of processing obligation on controllers and processors, that's replaced with a duty to keep appropriate records of processing.
What's the difference?
Well, not a massive difference. I mean, there are certain categories of information that you would no longer need to retain. The one significant change is that this right doesn't apply to organisations with fewer than 250 staff unless they're carrying out high-risk processing. And then the type of information that needs to be recorded, say, differs depending on whether they're controller or processors or controllers. It's kind of where the data is, why you're processing it, who you're giving it to. And actually that's interesting because under the existing ROPA requirement of processing, you would identify some categories, recipients or categories of recipients, where this is simply who are you giving it to, so it could be more specific.
Yeah.
And where the data is, whereas the processor has to record a lot less. It's simply who they're processing data for, where that data is. Then you've got the data protection officer role. That's now replaced by the senior responsible individual, and that's where the processing is carried out as high-risk processing, or the controller is, or processor is a public authority. A controller's data protection officer, sorry, the senior responsible individual officer's tasks are not that different from what they are now. The processor role really is simply to monitor compliance, be a contact point, and cooperate with the information exchange.
And you've already mentioned cookies. Are there other changes that are being brought into the privacy and electronic communication regulations, the sort of e-privacy space?
Yes, so I mentioned before about the fact that it's sort of reserved position on the kind of the cookie ban, as it were. So there will be the ability to have regulations down the line to allow for automatic preferences to be given when visiting the website using technology. But for now, they've provided for more exceptions from the requirement for consent for certain cookies. So, for example, we don't need consent where the cookie is used for statistical purposes. So how it's used to make improvements to mine, that's analytics. the way the site appears or its functions in order to reflect these preferences, and also includes, for example, security software updates. They also give more examples of where storage or access is strictly necessary to provide a service requested by the subject. But in fact, these really reflect guidelines, and guidance we've already had for some time from the regulator. So it talks about security, authentication, fraud, recording selections made by the subject, for example, shopping basket. So yes, those are kind of really just formalising guidance that we already had. And then there's actually some interesting developments around marketing. So there are some measures to tackle nuisance marketing. So there's a new duty on communication service providers to notify the information commissioner if they suspect persons contravening PECR. So, for example, by unsubstantiated calls or emails. The fines that can be imposed now are aligned with the GDPR. So they'll be GDPR the same. And actually, sorry, going back to that communication service provider obligation, if they don't make the notification to the information commissioner where they suspect there's been a breach of the marketing regulations within 28 days of becoming aware, they could be issued a £1,000 fixed penalty fine. So that's interesting. They've also extended soft opt-in to allow for use of marketing communications for non-commercial purposes.
So there's the requirement not to have to get consent.
Yes.
If you command the soft opt-in exception.
By way of opt-out, where that opt-out is not taken up. It's only your own purpose for communication. So charitable, political parties who are sending non-commercial communications could rely on that extension to that opt-out based approach to marketing. One big question for organisations is going to be what difference will this makes in practice. Particularly if they actually consider themselves to be compliant already with the GDPR.
Yeah, I think it's a really important question because there is this huge new law that we've got to kind of get our heads around. But if you're already complying with the GDPR, does it make any difference? And I think apart from these very specific instances, such as the one that Sally you just mentioned with the communication service provider, there may be some very small circumstances where it does seem to have a higher requirement, a stricter obligation. There's to be some tweaks, which I think are worth exploring in a bit more detail. I think generally speaking, for most organisations, it won't make any difference because essentially, if you are already complying with the GDPR obligations, you will also comply with whatever new law that we get in the UK following the passing of this bill. I think that is almost certainly the case. And in any event, it would be probably very unlikely for the UK law to either stray very, very considerably above the standard of the EU law or to stray considerably below it, just because that would seem an unusual step to take, although obviously we'll have to wait and see what any new Prime Minister will do. But given our market and all the sort of reasons of history, culture, and the economy is so tied into a European approach. So I don't think it will make a big change, but we'll have to wait and see what the final bill says.
So that's organisations, but what about the Information Commissioner? Is there going to be any changes down the line for that?
So there is a big change coming for the Information Commissioner because the ICO, as we know it, will be abolished by this bill. That's the proposal. And we will get a new Information Commission. So we're obviously still going to have a regulator, which is a good thing. But there is going to be a restructuring of the ICO, and we'll have to wait and see exactly what that looks like. I think the other change will be this relationship with government. And Sally, you've already mentioned some of the new powers, new sort of resources available to the Secretary of State. And it's clear from some of the consultation and reaction to the consultation that there were some real concerns about some of these proposals undermining the independence of the ICO. Now, I think that what we've got in the bill doesn't go as far as what was proposed. So, for instance, the Secretary of State doesn't have the power to review the ICO, which was one of the proposals. But at the same time, the ICO is still expected to have regard to the strategic priorities that the Secretary of State is going to give for the ICO, which again is not something that we've had in the past. Another thing to mention, the ICO will have to put any codes of practice to approval before the Secretary of State, before they go to Parliament, which again is not something that we've had in the past. So there are some definite shifts in terms of, I guess, authority or influence of how the law is going to shape up. One other aspect to be aware of is that just in terms of complaint handling, things will look different for the ICO because this bill is going to give the Information Commissioner or the Information Commission more power to effectively say, you individual complainant, if you haven't gone and complained to the controller, you ought to do that first before coming to us. And if the controller hasn't dealt properly or fully or finished dealing with your complaint, you have to wait for that process to run its course before complaining to us. So that should, again, have an impact on the workload of the ICO. I guess that's one of the reasons why it's been introduced. And we'll have to wait and see how that then factors into the way that controllers and others will have to deal with complaints in the future.
Just one other question. So when I talked earlier on about the agenda around encouraging innovation, I think AI has been a big sort of looming priority for the government to try and provide an environment for innovation, particularly in that space. So what does the bill have to say about AI technology and automatic decision making?
Yeah, it's a very topical question, because the government has just published its own paper on AI, which is sort of alongside this bill.
Yeah.
And it's worth saying that at the moment it looks as though it's going to be more of a self-regulatory approach in the UK, although we may get to legislation in the future. I guess in the context of this bill, the interesting point to look at is the changes to Article 22, which, as many of us will know, that's where the rules around solely automated decision-making are set out. And what the bill does is it clarifies what solely automated decision-making means. It says, well, that is where there's no meaningful human involvement in taking the decision. But it also has shifted some of the rules that we're used to under Article 22 fully into where you're using special category data in the context of AI systems for automated decision-making. So actually, the implication of this is that some of the other ways of processing just normal, sort of non-special category data, personal data, are not subject to the stricter rules that we're used to under Article 22. So logically, you should be able to process personal data for solely automated decision-making, relying on legitimate interest. I think that must be one of the logical conclusions to the drafting that we've got here. But certainly it's also worth stressing that there are important safeguards set out for this kind of automated decision-making that are now specifically mentioned in more detail in the bill. So things like transparency to individuals about decisions, enabling individuals to make representations, to obtain human intervention and to contest the decisions. So there is a lot more there to be aware of, is what you're specifically expected to do for automated decision-making. We ought to move on, given time, to see whether there are any questions. So,
so I've got one here, which is around cookies and whether targeting cookies will still require opt-in consent. And I take that question to mean sort of, advertising, personalisation cookies, and yes, so the exceptions don't extend to advertising cookies, so consent would still be required for advertising, targeting cookies in that sense. However, obviously there is still got that reserved Secretary of State position. So at the point that there's comfort that technology can enable individuals to express objections, preferences through, for example, browser-like technology, then it may be that that will have a broader impact on the removing the requirement to collect consent. At the moment, yes, consent
is still required. So one of the questions I have here is, how significantly will the final version of the bill change from the draft bill, and will there be a 2-year window to implement the changes? So that on that first part, I expect that unless something dramatically changes in terms of government policy, that the final version of the bill will not change significantly from the draft bill. I think, from what I understand it, there's been quite a lot of work that's gone into this draft bill over quite a long period of time. And as those of you who've looked at the draft bill, you'll see it's very detailed in terms of the way that it's been drafted. So I would have thought there may be a significant change of government policy. That is always possible. And again, this very much depends on who will be the Prime Minister from September. But my instinct at the moment is that it won't change significantly. The second part of this 2-year window, I think that is correct, that there was a 2-year window for the 1998 Act, for instance, the Data Protection Act. So it will, I guess it might be the same period of time, it might be slightly shorter, but I would expect something like that will be in the bill.
Yeah, so another question we've got here is around the change to data protection impact assessments. and what would an assessment of high risk processing involve. So under the sort of accountability reforms, I would say, proposed in the bill, the data protection impact assessment obligation would be replaced by what's called an assessment of high risk processing. The scope of that is broadly similar to what we have now. In conducting the assessment, you would have to set out the summary of the purposes for which data is being processed. You need to assess if that processing is necessary for that purpose, assess the risk of the processing generally, and also how you're going to mitigate that risk. So it's sort of a cut down version. One thing that's important actually around that risk assessment process is that the obligation to consult the Information Commissioner is now no longer mandatory, it's now a voluntary consultation, so there's no obligation to consult the Information Commissioner if the outcome of the risk assessment suggests a risk.
So one of the questions I have here is there any impact on processors with EU controllers? I'm guessing you were talking about a UK processor who is got customers who are in the EU. So I suppose the first point to mention there is the UK processor itself caught by the EU GDPR? Because if it were caught by the EU GDPR, it would need to still comply with all the EU GDPR requirements in any event. But on the face of it, the impact of the bill, there would be things around accountability that would change for UK processors. So perhaps not have to appoint a DPO, perhaps not have to do a DPIA, those type of things. And the record of processing obviously would be different. So in that sense, there is some differences there for UK processors. There's no change, as it were, to Article 28, which is the clause or the article which sets out the requirements for contracts between controllers and processors. And of course, the UK processor would still need to comply with its contract with an EU controller, an EU customer. So in that sense, there may not be much real impact, apart from, as I say, around some of the accountability obligations, which you may be able to have a lower standard of effort, I suppose, because that's what the UK bill is suggesting going forward.
Yeah, so I've got a question about arising from the new replacement of the DPO role with that of the senior responsible individual, and whether companies can still have an in-house DPO. And yes, the answer to that is yes, because you say the roles are broadly aligned. It's just in many ways it's just a title that has changed. And also controllers are going to have, there are going to be controllers out there who have feet in the EU, for example. They're going to have presence in more than just the UK, and it would make sense in that situation, for example, to have a DPO and apply that role and those tasks in the UK equally. It doesn't negate the requirement to have a DPO in the EU.
So the question I have is, what does the bill say about anonymisation? And the bill actually doesn't, as it were, include, here is our definition of anonymisation. But what it does have, this is in clause 1 of the bill, is some new provisions around, firstly, a new definition of pseudonymisation is in there, but it also includes, I guess, a bit more of a test about how you identify a living individual, what is an identifiable living individual. And within that, you will see, some of you are very familiar with the recitals in the GDPR, which is where it currently sets out the sort of test around what is personal data. We'll see that now included on the face of the law more specifically, and effectively brings it into a bit more of a relative test. So you're moving away from a more absolutist interpretation of anonymisation to sort of bring it back to, well, whether an individual is likely to be identifiable by reasonable means. And there is a number of different sort of provisions here, which talks about the time, effort and cost involved in identifying the individual and the technology and other resources available to that person. So I think that's where we will see a bit of a shift to perhaps what we've seen some of the European institutions talk about when they indicate that data is fully anonymised. I think the UK position may be a little bit more nuanced. I think we have now come to the end of our time together, so although there's a lot more to discuss and consider with this new bill, we hope that you found this helpful and interesting, and we will follow up with any questions which we haven't been able to answer personally. The recording of this webinar will be available shortly on the Global Data Hub website, and actually at the end of September, our Global Data Hub newsletter will be covering the UK bill in more detail. So thank you very much for tuning in, and we hope that you've enjoyed this session.